Welcome back. We move on now to the webinar organized by Lincoln Alexander School of Law at Toronto Metropolitan University, Canada, and Massfield LP. Here are the highlights from that event.
As many of you know, Nigeria's justice system has witnessed its fair share of some of the instability that has faced Nigeria as a country over the years. In this sense, the administration of justice is challenged by inefficiencies that impact access to justice for litigants on the one hand, and a crisis of governance involving operators of the justice system on the other. In responding to these issues, we've put together two back-to-back panel discussions.
With these words, the moderator of the webinar, Dr. Uche Ngwaba, an assistant professor at the law school, set the tone for the conversations on the sub-theme, efficiency and access to justice, discussed at this webinar of the Lincoln Alexander School of Law and Massfield LP, a dynamic future-focused law practice. The webinar brought these key stakeholders from the legal community together to explore the future of Nigeria's legal system. The first speaker, Senior Advocate of Nigeria, Anthony Idigbe, in his contribution, examined the history of court governance in Nigeria, highlighting some of the weaknesses.
Further, there is inconsistent jurisprudence on judicial governance. For instance, in Nganjiwa against FRN, it was held that only the NJC can deal with corruption charges, and a judge in active service cannot be investigated or tried in a court of law unless such a judge is first removed from the bench. But contra the case of Onedian, where a former CJN was tried before the Code of Conduct Tribunal while he was in office. So some of the consequences of the weaknesses in the governance structure include nepotism, cultism, corruption, promotion mentality within the judiciary, exclusion of career commingling at the top echelon of the judiciary, inability and lack of willingness to attract the best to the judiciary consistently, poor management of the justice delivery system, delay in justice delivery, decline in quality of judgments and justice obtainable, increase in resort to self-help by the citizens, rise of non-state supported alternative justice systems such as OPC, Bakassi boys, herdsmen, etc., breakdown of rule of law, and prevalence of impunity. Now, are there remedial tools available for rescuing the judiciary and guaranteeing the future of the institution? I think there are, but it may involve constitutional amendment. It may also involve the implementation of the MBA recommendations and the draft bill for reform of the legal profession.
The other speakers proffer some solutions and reforms necessary for the future of Nigeria's justice system.
Let me bring in the views of somebody everybody knows about, Adam Smith, the father of the theory of political economy. He wrote that book in 1776 entitled The Wealth of Nations for short. In it, he examined the different factors that contribute to the economy of a nation. Above all, he said, there's nothing that gives greater encouragement and most effectual encouragement to all sorts of industry, and remember here, all sorts of industry, than the administration of justice. It is for that reason that proper funding of the administration of justice is something that must be done for the benefit of society as a whole. And I will again move it to the access of people to justice. The proper funding of the judiciary requires judges to be paid adequately and that pensions secured adequately. It is for the good of the people that this must be done.
In order to facilitate justice delivery in Nigeria, some of the other things we need to look at are one, infrastructure, and two, manpower. And those are the two areas where we still have a lot of gaps. I think the pandemic sort of showed that very clearly when the pandemic hit. Apart from the courts, every aspect of our justice delivery system is lagging behind when it comes to technology. If you look at the law enforcement agencies, a lot of things are still done physically and by hand, not enough records that you can access and process to be able to deliver justice at the speed and at the pace that is required for the 21st century.
But in a country like Nigeria, for example, where infrastructure, electricity, power supply is critical in terms of any technological onboarding you want. You also have the issue of economic, the fact that the resources that are allocated for this public service should be provided in a manner that does not exclude the generality of people who cannot afford alternative sources of power in order to access this technology when it is deployed. And I would also want to end my intervention around the classes of people engaging the justice system. So when you have women, children, or people who traditionally have been excluded from society in terms of opportunities, whatever methods we deploy have to definitely take into consideration gender responses, also responses in terms of the ages, the status of people engaging in it, to ensure that the system that is deployed does not discriminate and provides a level playing field as much as possible.
A second panel session dwelt on the operators of the justice system, touching on topics such as qualification and recruitment of judicial officers, continuing legal education, and training and remuneration of non-judicial staff.